for a brief introduction. Thank you.
Thank you, Chair. Dear colleagues, we are taking on board a very important topic, which you have already had the chance to discuss on a preliminary hearing in December in Yerevan. This topic is directly linked to the issue of the use of frozen assets, the issue which has become especially important in view of the circumstances and the international environment and how it has changed in the last 2 weeks. The use of Russian frozen assets, public, private, in whatever banks they sit across the world today, is crucial for the defense and security of Ukraine, for the defense and security of Europe, and the defense and security of democracy. This is why I would like to call on you to view this topic in the light of this newly uncovered and newly important urgency. And with this, we have several speakers with us today. But however, before I go on to introducing them, I'd like to also inform you that unfortunately, at the end of January, the Federal Supreme Court of Switzerland dismissed the final appeal lodged by Hermitage, paving the way for almost $14 million in seized assets to be returned to the Russian holders. All of whom are involved in the fraud exposed by Sergei Magnitsky. Two of them, Vladlen Stepanov and Dmitry Kluyev, are currently sanctioned in the United Kingdom and the United States, Canada, Australia, Latvia, Estonia, and Lithuania. So this is the part of the bad news. Another part, I'll start with the bad news straight away. Another part is that not all of the speakers and distinguished experts whom we have invited today have agreed to join us. For example, the Swiss authorities are not being very cooperative at this point in time. We have invited Mr. Michael Lauber, the former Prosecutor General of Switzerland, to participate in today's hearing, and he declined due to confidentiality obligations associated with his previous role as Prosecutor General. And although later this week I also will be visiting Bern for a fact-finding mission linked to this report, the Swiss authorities have also not given the okay to meet with the Prosecutor General's team. This is something that I also would like you to know and to take into account. So now to our discussion today. I'm very pleased, however, that Sir William Browder is with us and also Professor Mark Pieth online. Both of them have contributed greatly to this report and the way that it is shaping up, and hopefully their further contributions and comments will allow you to come to your own conclusions. So William, he is the founder of Hermitage Capital. He's also the CEO. And he heads the Global Magnitsky Justice Campaign. This is a campaign, an NGO, which seeks to impose targeted sanctions on human rights abusers and corrupt officials across the world. Since Sergei Magnitsky's death, Sir William Browder has been tirelessly campaigning for justice and accountability. And Bill, we are absolutely thrilled that you are with us today and able to contribute to this very important discussion. Professor Mark with us, he is online. Dear Professor, we hope you will be able to comment and to take part in the discussion, although we understand that the technical possibilities are not ideal. We would much love you to have you here with us and be able to engage both in the official manner and also have further discussions with the members of our committee. In any case, the professor, he is the professor of criminal law at the University of Basel and one of the most prominent experts on anti-corruption. The experience of Professor Pieth includes being a founding member of the Financial Action Task Force, the FATF. He has chaired the OECD Working Group on Bribery for 24 years and has been the member of the UN Independent Inquiry Committee into the UN Iraq Oil for Food program, and also chairing the Independent Governance Committee overseeing the reform process of the FIFA. Thank you very much both for your presence here today. So without any further ado, I would like to turn to our experts to enlighten us further on the details of this topic.
Thank you, Ms Vasylenko. And could I begin by thanking both of our experts for making themselves available. It is greatly appreciated by this committee and by the Parliamentary Assembly as a whole. And first of all, invite Sir William to address us. Thank you, Sir William.
Chairman, members of the committee, Lesia, this is a great honor to be here and a great opportunity. And before I get into the story, I just want to say a couple of things about the relevance of the Parliamentary Assembly of the Council of Europe in relation to the Magnitsky justice campaign. When Sergei Magnitsky was first arrested before he was killed, the special rapporteur of the Parliamentary Assembly of the Council of Europe took up his case and began questioning the Russian authorities about why he was in jail. And this was when Sabine Leuthauser-Schnarrenberger was in that role. And it was the first moment that the Russians had any serious questions about why he was in jail. Now, of course, many of you will know that Sergei Magnitsky was ultimately killed in jail by the people who he exposed of committing a $230 million crime. And at that moment, I came back to the Parliamentary Assembly of the Council of Europe and again told the story, and Peter Omzicht, who's here, took up the case and proposed a special rapporteur into his murder. And Andreas Gross became the special rapporteur in that case and wrote an absolutely damning report about his murder, about the impunity, and about the cover-up by the Russian government. That was also in his report. He also called on the Swiss not to, or to investigate the money that was found in Switzerland. It's been a, and I should also point out that in addition to Sergei's murder, then we had the Nemtsov murder. The Parliamentary Assembly took up. We have the false arrest of Vladimir Kara-Murza, and all of these cases. This has been an extremely relevant body, and so for you to take up this particular part of the Magnitsky case is both important, relevant, and will have impact. And so I just wanted to say that before I get into the specifics of this case, because it really is something important that you do, and it has and it will have an impact, and that's why I'm so honored to be here. So as Lesia said, my job before was as the head of Hermitage Capital Management. Hermitage Capital Management was an investment fund designed to invest in Russia after the fall of the Soviet Union. Many of you know me, some of you don't. So for those of you who don't, I will give you a bit more granularity of the story. I went to Russia to invest in publicly traded companies in the newly formed capital markets. I created what became the largest investment fund in Russia. The portfolio was at $1.45 billion in size. I discovered that all of the companies that I had invested in, companies like Gazprom, Sberbank, Surgutneftegas, these are all big Russian companies, were basically being robbed blind by the oligarchs in Russia and by corrupt government officials. And there were many people who just sort of turned the other cheek and said, that's just what happens when you invest in Russia. But I felt that it was my responsibility to my investors and to Russians more generally not to turn the other cheek and to say something about it. And so together with my colleague Vadim Kleiner, who is sitting here, who's head of research, we started to investigate how the oligarchs and corrupt officials stole money from these companies, and then take that research and share it with the international community. And we did so with the cooperation of the Financial Times, the Wall Street Journal, Washington Post, etc. There was a big appetite for the research that we did. We named and shamed many officials who were involved. And as you can imagine, that made a lot of people very unhappy. And in November of 2005, I was expelled from the country. I was declared a threat to national security. And then after that, my offices in Moscow were raided by the police. 25 police officers raided the office. 25 police officers raided the office of the law firm where we kept all of our corporate documents, and they seized all of our corporate documents. Now, thankfully, between the time that I was kicked out and our offices were raided, we liquidated all of our holdings in Russia, and I evacuated my staff. And so I thought that I was safe. But it turns out that when the documents were confiscated by the police, they used these documents to fraudulently change the ownership of our investment holding companies, which at this point were empty because we had taken our capital out of the country. They fraudulently re-registered the holding companies. And at this point, I was concerned not for economic reasons, because there was no huge economic loss, but I was concerned that if police were stealing companies, one day I'll be walking through Frankfurt Airport and I'll be arrested on a Russian warrant. And so I went out and I hired the smartest lawyer I knew in Russia to investigate, a young man named Sergei Magnitsky. Sergei worked for an American law firm. He started to investigate, and he came back with the most unbelievable conclusions. What he discovered was that the people who stole our companies, once the companies were in their possession, they went back to the tax authorities and they said, these companies reported $1 billion of profits in the previous year. And they said, those profits don't exist. There was a mistake made. The companies made no profits, and they came up with a fraudulently, or a sort of fake way of explaining this. Therefore, since there were no profits, the taxes that were paid in the previous year, $230 million, was paid in error and should be refunded. They applied for this tax refund, this illegal tax refund, on the 23rd of December, 2007, and it was approved and paid out the next day. It was the largest tax refund in the history of Russia. It was paid out in one day on a fraud. If you had legitimately overpaid $5,000 of taxes in Russia in 2007, you would probably still be fighting for it today. But $230 million was paid out in one day on a fraud. Obviously an inside job. Sergei and I were both shocked and appalled by this. And we, at the time, assumed this must be a rogue operation. This wasn't my money that was being stolen. This was the Russian government's money, taxes that we had paid to the Russian government being stolen from the Russian government. And we assumed that at the time, we thought Putin is a patriot and a nationalist. He may not be a very nice guy, but we thought he would be very concerned if his officials were stealing this type of money from his country. And so we decided to expose the crime. Sergei wrote criminal complaints to every different law enforcement agency in Russia. I went to the media, to the newspapers, television, radio, and Sergei gave sworn testimony against the officials involved. And we waited for the good guys to get the bad guys. Well, it turns out that there were no good guys. Instead of arresting the people who Sergei exposed, they arrested Sergei. They put him in pretrial detention. They tortured him for 358 days in the most appalling ways, which have all been documented here by the Parliamentary Assembly of the Council of Europe and Andreas Gross's report. And they killed him in police custody on November 16th, 2009, at the age of 37. Since his murder, I put aside all of my business activities, and I've made it my life's work to go after the people who killed him to make sure they face justice. And for the last 15 years, that's what I've been doing. Now, there were several different parts of our justice campaign. Many of you will know about the more public part of our justice campaign, which was the Magnitsky Act. The Magnitsky Act is a piece of legislation which now exists in 35 countries, which freezes the assets and bans the travel of the people who killed Sergei Magnitsky and the people who commit similar human rights abuses. But the other part of our campaign, which is not as well known, but is what the subject of today's hearing is about, is we said to ourselves, who got the money? Who got that $230 million? And let's make sure that those people cannot enjoy that money, that that money is frozen and seized, and that the people who took that money are prosecuted. And we started to look for that money. And it's not easy to find money that Russians steal. It's a very hard thing, but several things happened that made it a little easier. One person who was involved in the crime, who fell out with his co-conspirators, came forward and he said, I've got bank statements from Switzerland to show you where some of that money went. And so we took his information, we analyzed it, we determined that it was credible, and we provided the information in 2011 to the Swiss Attorney General's office. In 2011, shortly after we provided that information, the Swiss Attorney General froze the accounts that belonged to the individual who had gotten the money. He happened to be the husband of the woman in the tax office who approved a big part of the $230 million tax refund. She approves the illegal tax refund. Her husband gets the money at Credit Suisse in Zurich. The Swiss authorities freeze the money. We then get some more information from other sources. We provide that to the Swiss authorities. They freeze more money. They freeze money belonging to a man named Dmitry Kluyev. Dmitry Kluyev is the head of the Kluyev Organized Crime Group. And the Kluyev Organized Crime Group was the crime group that was like the general contractor of this crime. They were the ones organizing the police raids, organizing the banks, doing all that kind of stuff. And then they found money belonging to a company called Preverzone. Preverzone received some of the money that could be directly linked through bank transfers to that account. So they have frozen, at this point, around more than $20 million. And it was considered by us and by other financial investigators as a robust response to the whole thing. And I was invited to give evidence in Switzerland on more than one occasion to the prosecutor at the time. Vladlen Stepanov, the husband of the tax official, was invited to give evidence. The whistleblower who gave us the information was invited to give evidence. It all looked like a very solid investigation. Then a new attorney general shows up. His name is Michael Lauber. Michael Lauber is the new attorney general. The lady who was the assistant attorney general running our investigation left. We don't know whether she quit or was fired. And everything then ground to a halt. Completely and absolutely. No more investigations, no more invitations, no more, and we started writing letters. What's going on? What's happening? Why is this happening? And there was complete silence. It had changed from a robust investigation to a stonewalling. Then the most interesting thing came out after some period of time, which was that a man named Vincent Schnell was a police investigator who spoke Russian in Switzerland, who was hired, a friend of Michael Lauber, who was hired from the Swiss federal police to come and join the prosecutor's office in investigating the money. He comes on, and all of a sudden, he starts going on hunting trips with his Russian counterpart, hunting trips to places outside of Moscow, hunting trips to other places, all paid for by Russian oligarchs. And there was one famous hunting trip. It was a bear hunting trip in Kamchatka. They flew from Moscow to Kamchatka on a jet, then took a private helicopter from Kamchatka airport to someplace in the mountains, stayed at an oligarch's hunting lodge, an oligarch named Iskander Makhmudov. He's on the Forbes list. I think he's number 43 or something like that in Russia. At this hunting trip, he is asked to scupper the Magnitsky investigation. He comes back from the hunting trip, and he invites one of your former colleagues, Andreas Gross, who wrote the report condemning Russia. He invites him in Switzerland. So this is a Swiss prosecutor inviting a Swiss politician who wrote a Parliamentary Assembly of the Council of Europe report condemning the conduct of Russia. And he starts interrogating him, trying to discredit his report. Eventually, he was asked to come back to Moscow for an emergency meeting in relation to this case. Because he was officially working for the Swiss Federal Police, as a part of their protocol, you have to ask your boss for permission to travel abroad. He was not given permission. He went anyways, at the expense of the Russians. At least in Moscow, we don't know how he got there. Everybody in the Swiss Federal Police thought this was very suspicious. And he was ultimately investigated by the Swiss Federal Police, and they filed a criminal complaint against him for bribery in relation to the bear hunting trip. So they filed a criminal complaint against him for bribery. So that's the police filing a criminal complaint with the prosecutor's office. Michael Lauber, who's a friend of his in the prosecutor's office, whittles it down to not bribery, but to the lowest possible charge. He's then convicted, but given a suspended sentence and a fine of $5,000. But all of his work to discredit the Magnitsky investigation stayed within the file, within the criminal case file. And his successors, whether they're corrupt or whether they're just ignorant, decided to take his conclusions at face value. And they decided to terminate the criminal case, to not charge files, or to not file charges, and to give back $14 million to the individuals involved in this case, giving back money, giving back all money to Dmitry Kluyev, giving back 99% of the money to Prevrazone, and giving back 60% of the money to Vladlen Stepanov. As Lesia mentioned in her introduction, Dmitry Kluyev and Vladlen Stepanov are sanctioned by the United States, Canada, UK, Australia, Estonia, Latvia, and Lithuania. So the Swiss government is basically going to be in violation of all those countries' sanctions. And here we are in a war. There's a war going on right now in which we're trying to hold back economic resources to people connected to the Russian government. And the Swiss government is acting in defiance of both sanctions and the principle of war that we have going on. The way that they justify this is by saying that it's so complicated that they can't prove that the money was dirty. And the way that they say that is that if the money was just sent from one account in Russia to one account in Switzerland, they would take all of it. But because it went through one account and then another account and another account, they have to subtract out money each time it goes through one of the accounts. So, and this is their technical argument for why they're not taking all the money. And so what would that imply is that if you're a money launderer, you say, okay, I'm just going to set up 100 accounts to move the money through because I know then in Switzerland, when it gets there, everything will be fine. They've also basically rejected the fact that this husband was married because he produced a fake marriage certificate or a fake divorce certificate, which he produced after the fact. And so, well, they're not married, even though the woman who approved the tax refund the money goes to her husband or ex-husband, but that's okay. If he's the ex-husband and there's a certificate produced, then no problem there. And then they sort of threw their hands up in the air and said, this is just too complicated a case to investigate. And then they did something which is truly pernicious. So as you can see, I'm very passionate about this. I have a lot of facts at my fingertips. I'm a well-resourced guy. I could do this for a long time and I won't give up. And so the Swiss figured the biggest problem is me. And so the best way to stop me is to exclude me from the case. And so they said, I'm no longer an interested party in the case. Why am I no longer an interested party in the case? I didn't suffer any damage because it was the Russian money, the Russian government's money that was taken, not my money. I didn't suffer any damage. Sergei Magnitsky, my lawyer, was murdered. I had to flee the country. Vadim had to flee the country. I spent tens of millions of dollars on legal fees defending against bogus Interpol arrest warrants and Russian extradition requests, lawyers in all different countries, lawsuits and other types of attacks, but I didn't suffer any damage. And then to add ultimate insult to injury, the Parliamentary Assembly of the Council of Europe has taken up this case, which is truly wonderful, has applied to the Swiss authorities to give their response. And as I understand, they're refusing to meet. Their refusal to meet should tell you everything about what's going on here. Switzerland is not Russia. They're a member of the Council of Europe. They should absolutely meet, disclose, answer questions. And if they refuse to, based on this fact pattern, I think you can draw your own conclusions that Switzerland is not a legitimate law enforcement country, but a country that should be on a blacklist and treated as a banana republic when it comes to financial and economic crime. Thank you very much.
Thank you, Sir William. Can I now invite Professor Mark Pieth to address us? I understand he has a particular expertise and views on the proportional confiscation method that Sybil mentioned. And it may be that he'll touch upon that in the course of his address. Professor, could I invite you to address us? Thank you.
Well, thank you very much, Chairman, members of the committee, and Madame Rapporteur. Indeed, I've spent a lot of time on the topic of money laundering and confiscation. I must declare that following 1989, I was the head of section on economic and organized crime with the Swiss Ministry of Justice, and amongst other things wrote the Travaux Préparatoires for the anti-money laundering legislation. So I've been quite a bit involved with the topic of money laundering, and I will come to this in just a moment. In my view, I believe that the Office of the Attorney General, as well as the Swiss courts, have committed two serious mistakes. First, the method of calculating ill-gotten gains is highly problematic and it benefits money launderers. I will come to that in a second. The second mistake, Bill has already mentioned it. The Federal Supreme Court has seen to it that Hermitage and its companies have lost their status as civil claimants and could no longer appeal the mistakes of the OAG, the Office of the Attorney General, and the Court of First Instance. Now, turning to the question of calculation of ill-gotten gains, this may seem a technical issue to you, but it has dramatic consequences. It is correct that at the end of the chain, when you take a decision as a court, only illegally obtained assets can be laundered. That is absolutely correct. However, there is a fundamental principle that has been over seen here. In this case, the principle that substitutes of illegal money, of illegal gains, remain illegal throughout the entire chain of replacements. So if at the outset 100% of the money stems from fraud, the chain of funds, in whatever way they are transferred or transformed in on any further level of laundering, simply remain illegal. Only at the very end of the process, one would then assess whether the illegal funds and their substitutes could possibly have been mixed with potentially legal means or assets of which the illegality cannot be proven. So instead of actually going through the entire chain step by step and reducing the percentage of illegal assets continuously, in order to have at the end single percentages, like I think Bill has mentioned 50% in one case and 1% in another case, to be carried over as illegal, you have to actually follow the chain of illegality from the beginning to the end, and illegal stays illegal. It does not suddenly turn into legal funds. Now, as I've said, this may seem very technical, but it has huge consequences. Now, I said there was a second step that is equally problematic. That is to rob the victim of fraud and ensuing laundering of its appeal rights by simply excluding the status of civil complainant. This was achieved by ignoring the fraud by officials against Hermitage. For the OAG and the Swiss courts, only the Russian state seems to be the victim. This was a consequence of mutual legal assistance request and procedure. One actually, up to the bitter end, considered Russia the victim of the scam, and Hermitage as a sort of a secondary victim. And the Supreme Court in Switzerland said, well, victims are only victims if they are primary victims. A secondary victim of the kind of Hermitage would not count as a victim. I have publicly denounced this as a form of overly formalistic, an approach that is overly formalistic. But this is maybe putting it a bit too simple. It's actually much worse. What happens overall is that not only the Swiss banks involved here, but also Switzerland's justice system have acted in favor of fraudsters and launderers as far as they're involved in this case. And this is extremely serious, as it makes Switzerland look like one of the biggest offshore centers. We should be aware that Switzerland takes care of about a quarter to 1/3 of all private funds that are held worldwide. So Switzerland matters in this area. And what we are seeing here is that its institutions are ready to shield fraudsters. Now, if you allow me, Chairman, just a final word on the question of sanctions. Now, Switzerland does not adhere to those Magnitsky sanctions, as many other countries do. On the Russia war sanctions, Switzerland takes the position that it simply follows, and this it does to some extent, not entirely, follows the sanctions that the European Union enacts, not though UK, not US or G7. Um, what what actually happens is that people like Kluyev and Stepanov, they are not oligarchs. They're too low in the food chain to be in the Russia sanctions of the European Union, so they will not be sanctioned there. It is open whether Swiss institutions, Swiss banks, will risk to be in breach of the Magnitsky sanctions that many countries have enacted. After all, these banks do have subsidiaries in those countries, so it's a bit risky, and they are certainly at a loss what to do at this moment. But the situation is very unclear on the sanctions level. Overall, I would like to finish by, for me, it is as a Swiss citizen and as someone who has worked on money laundering, fraud, corruption, and so on all his life, it is embarrassing to see what has happened here. Thank you, Chairman.
Thank you, Professor, and thank you to both our experts for their contributions. Could I now open the floor to colleagues for questions? And I suggest that we'll take 2 questions at a time. And if you could indicate which of the experts, or both if necessary, you would like to address your question. Pablo Hispan, first of all,
Yes.
thank you.
Thank you, Mr. Chairman. To Mr. Browder, it's about a new U.S. administration, how it's going to behave. Or do you think that the new U.S. administration is going to behave in this issue?
Not well. I think we're in a moment of existential crisis right now based on the events of the last 2 weeks as far as the U.S. is concerned. I mean, we could talk about this for hours, and it's probably a little bit too broad a topic, but let me just bring it back to where we are right now. In the meeting in Riyadh between Secretary of State Marco Rubio and the Russian Foreign Minister Sergei Lavrov, there was a one of the many things that was discussed was a preemptive loosening of sanctions to, quote, bring Russia to the table. I would be surprised if the U.S. doesn't do that, and I'd be particularly upset if the rest of the world followed. And so we're bracing ourselves for the U.S. to withdraw sanctions. To what degree do they withdraw sanctions? Is it just the oligarchs? Is it the government? Is it everybody? Is it Magnitsky offenders? I don't know. I mean, I'm watching my life's work for the last 15 years getting undone in a couple of weeks. And I can only pray that as arbitrary and as unexpected as these developments are, they might be arbitrary and unexpectedly change in the future because it's just so random, but I'm not optimistic.
I wonder, Sir William, if I could ask a supplementary. It does appear that in 2016, there was some exchanges between certain lawyers involved in the Magnitsky matters in Russia and what might be termed the Trump team at that time. I don't know to what extent you're aware of that. It had to do with the suggestion that they might bring forward some information regarding the Democrat candidate for the presidency. Are you aware of any further engagement between what's termed the Trump team and such individuals?
So what we know is that the Lesia Vasylenko, who is the lawyer for Denis Kotsiev, who is the owner of Preverzone, which is the company whose assets were frozen in Switzerland. They were also frozen in the United States, and also frozen in the Netherlands. And she was able, it wasn't 2016, no, it was 2016. It was June 9th, 2016. She was able to get a meeting with Donald Trump Jr., Jared Kushner, who was the son-in-law, and Paul Manafort, who at the time was the campaign manager for Donald Trump. This was after he was nominated, before he was elected president. And this was the famous Trump Tower meeting, if you remember that whole thing. And the pitch was that they had dirt on Hillary Clinton. In exchange, they wanted to get the Magnitsky Act repealed and to have me prosecuted by the American authorities. And this was before he was elected. That didn't seem to come to fruition. However, something did come to fruition, which was in 2018 at the Helsinki summit between Trump and Putin. It was right after the special counsel Robert Mueller, who is investigating Russian interference in the US political system, had indicted 12 Russian GRU officers for their interference. And the summit, that took place on the Friday. The summit was taking place on the Monday. At the press conference, after the summit was over, one of the journalists asked Putin, "Are you going to hand over the 12 military intelligence officers, GRU officers?" And Putin smiled and says, "Well, it's possible that we would. But if we did, we would expect goodwill and reciprocity from our American friends, and we would expect them to hand over Bill Browder, me." And it wasn't that was unpleasant, but it wasn't unexpected, because Putin has been after me ever since the Magnitsky Act was passed. I was top of his list. However, what was unexpected was what happened next. Was one of the journalists then asked President Trump, "What do you think about this?" And Trump said, "I think it's an incredible offer." And it was only 4 days later, when the Senate voted 98-0 not to hand me over, that the issue was then put aside. As you can imagine, I'm not feeling too comfortable traveling to the United States right now.
Thank you. Ms. Navika.
Thank you. I have a question, I think, to both of you, whoever would like to address. Actually, do you have, we've been talking about what's happened in the past as far as this case is concerned, but are you aware of such practices being underway right now? Is about, laundering Russian money, going to Swiss banks and so on. Is it still happening, and to what scale? Probably we would expect it is going on, but nevertheless, maybe you have some knowledge about that. So this is my first question. Whatever you know, what is going on now, not necessarily only in connection with your case, but also in the broader picture, how these practices now are being developed under also the war with Ukraine. Does it have any impact on whatever? So that's my first question. Second question is about the possible recommendations, because actually my interest is about in Switzerland, what's happening in Switzerland. I am afraid that we might have very little impact on Russia and what's going on there. Nevertheless, Switzerland is the country which is helping those criminal practices. So, do you have any recommendation for the PACE reports or resolutions? What recommendations we could formulate to the Swiss government in order first for the past action, but also to prevent those actions to be continued on the side of Switzerland? Thank you.
Thank you. Could I invite Professor Pieth to come in first of all on those points, if I may? Thank you, Professor.
Yes, please. Thank you. Okay, well, I'm certain that such practices, if you want, are going on. They're always going on. There is money laundering in many places of the world. including Switzerland. But one has to say, first of all, if you run a major financial center, you are exposed. So it is understandable that there would be attempts to launder money. The real question is a financial center big? Would it be concerned, or should it be concerned? And is it adequately regulated? And the question for Switzerland here is really, does the Financial Regulatory Office, it's called FINMA, have they done their job? We've talked about the Office of the Attorney General a lot now, but the banks are supervised, and it is and the recipients of those funds. I think you've mentioned the Stepanovs. They were official. She was an official at the time, maybe not the top-ranking official, but still, I mean, the head of fiscal authority. Bringing millions is a suspicious incident. So, first of all, the question is, have the regulators done their job, and are they currently doing their job? So, coming back to your question, what should one actually do? I think one should use this case. Frankly, the case is over, it's done. We cannot change anything, but what we should do is one should use this case as an example. One should examine whether things went correctly, or whether it is actually a case of corruption, and use it as for lessons for the future. And in fact, Switzerland is at center stage here, but Switzerland is not the only place where such things happen. I think that has to be very clear.
Thank you, Professor. Sir William, would you like to add anything to those observations, please?
I second everything that Professor Pieth says. Very simply, from going forward, what should happen first and foremost is that this concept of proportional distribution, the proportional methodology of money laundering, which doesn't exist in any other country, should be eradicated. That Switzerland should pass a law to no longer allow this thing to happen. It's a loophole you could drive a truck through, and it shouldn't exist. And the Swiss, as you say, are not. This is not Russia. This is Switzerland. They're a member of the Council of Europe. They're part of a society of civilized people. Most of the time, they should react to the pressure, and they should not do that. There's one opportunity. The one place I will just slightly disagree with Professor Pieth is that the case is not over yet, in the sense that the money of Stepanov and Kluyev remains stuck in Switzerland because the banks, the two Swiss, no longer two Swiss banks, it used to be UBS and Credit Suisse, it's now just UBS. They're too scared to release it, because if they release it, they'll be in violation of everybody's sanctions. And so the money still sits there. It's an entirely feasible thing. For one recommendation of this report is that as long as that money is still in Switzerland, that the Attorney General's office reverses their previous decision based on the fact that they're no longer using proportional method to reinvestigate and to confiscate the money.
Thank you. Mr. Lacroix.
Merci, Monsieur le Président. Je vais m'exprimer en français pour être plus clair.
Thank you very much. I'm going to be speaking French. I would like to thank our two speakers who've given us so much food for thought this morning on these very obscure files. I have a question. I wonder who I should put it to. I'm looking at the para 29 of the report, and it says that Mr. Schnell, who is one of the protagonists of this case, spoke to Andreas Gross and interrogated him, and was taken to a meeting with Mr. and so on and so on. Now, I don't know how the Parliamentary Assembly reacted to this summons against a politician on this matter, which is concerned to us. There was clearly a desire to put pressure on a rapporteur from the Council of Europe. So I'd like to know what the Parliamentary Assembly did about this officially and whether it was satisfied with the result. If it wasn't, I suggest that the Parliamentary Assembly should lodge a complaint with the Swiss Confederation, and we should make sure that our current rapporteur doesn't suffer such pressure from a democratic state. Secondly, I would like to make a personal comment. In Belgium, we're dealing with an issue which is not entirely dissimilar. It's money laundering. And once again, we see that the National Bank and the Financial Markets Regulation Service and also the Financial Prosecutor's Office, it is in fact structural dysfunction amongst these bodies that allows this laundering to take place. So I'd like the rapporteur to be able to broaden the scope of this in order to have more general conclusions when it comes to money laundering. We're talking about very important matters when it comes to law enforcement, and I would like to wish you both every bit of luck, and also especially to Sir William Browder.
Answer your question, as you might appreciate. However, I wonder, Professor Pieth, if you have any observations to make on the points that Michel Lacroix just raised. Thank you.
Yes, thank you, Mr. Lacroix. I don't know technically what happened following Andreas Gross's interrogation at the time, but your second point, I entirely agree with. What we can see is a Swiss problem, but also an international problem. It is the result of similar events in other financial markets in other parts of Europe.
So, William, I don't know if you want to make any comment on those points. Thank you.
We have stayed in contact with Andreas Gross over the years, and I can say with 100% certainty that he didn't receive any type of official support from this awful situation he had, and I think that he would. He would value, and I think that everyone else in this organization would value some type of institutional response to what had happened, even if it happened a few years ago, and because it's all part of this mandate that the Swiss should be put on notice that you can't, that law enforcement was involved in a potential political interference and obstruction of justice, corrupt law enforcement, and so yes.
Thank you. Ms Vasylenko, would you like to come in with either questions or some further observations in light of the indication that you might broaden the scope of the present report? Thank you.
Thank you, Chair. I will do both, if I may, as you have suggested. So I will start with a general observation, and perhaps I will have another one after our other colleagues intervene. The general observation here is that this report tackles and has an important role of being a stop sign for a very dangerous precedent that is starting to unroll before our eyes. And it seems with this case, as Bill has further explained, and also Professor Pieth, is that Russia is almost testing the grounds for then introducing higher level cases of the same level. As Bill, you have mentioned, these perpetrators, they are too low on the food chain. They are not oligarchs per se. They are not being sanctioned under the EU sanctions list. And also the amounts which are in question, yes, they are considerable, but they are not in billions terms. 200 million, it's still quite a low number, to a low amount to be on the radars, on the international radars. So it's almost like this case is a test case, a pilot, to see how will the authorities react. And if the authorities react that they are suddenly able to make way to return the money to the perpetrators, or that suddenly there is no movement in the justice system, and that eyes can be closed and excuses can be made that this is too complicated, we simply don't want to deal with, then it's a green light for similar cases to go ahead with, and possibly with which will involve larger amounts and more complicated stories. So this is why I believe this report to be extremely important. I believe the work of Sir William Browder to be very important, and especially so the remarks by Professor Pieth, who knows exactly what he is talking about and what kind of methodology and legal arguments are being used for this. Again, thank you, Mr. Lacroix, for your comments. I think it's also very important, and we will find a way to integrate what you have suggested into the report and also into the resolution. As for the questions, they're minor clarification questions. You mentioned that, Bill, you mentioned that there's still the money of the perpetrators that remains. Is that the $200 million you're talking about that still sits in the Swiss banks? What is the fate of this larger amount of 200 million? And is there any way to retrieve it? And what will happen to it should the proceedings not have any further development? That's one clarification for you. And then for our esteemed Professor Pieth, could you explain to us also a bit in more detail about the proportional confiscation method to which everybody reverts to? What's interesting is whether there's any other jurisdictions that have been applying this method, and whether this is a method which has been widely used and supported by the FATF, or whether there are any problems with that method. And are these problems exactly what Bill Browder has been telling us about the Swiss actually finding it problematic to find links between various steps during the procedures of the crime? Thank you.
Thank you, Ms. Vasylenko. Professor, in addition to the points raised, could you perhaps enlighten us as to whether there are, as far as you're aware, any active steps or proposals within the Swiss legislature to address the proportional confiscation method, perhaps being complimentary by calling it a method? But if you could add that to your observations. But can I begin with Sir William? Thank you.
So, Lesia, when we're talking about 300 billion of frozen assets, the central bank, these are very. This almost feels like the change on the floor of your car, but there's about 8.5 million of money belonging to the Stepanovs, which is intended to be returned, which continues to be stuck there, and in Switzerland, which should be reinvestigated and confiscated. And in terms of the larger crime, this $230 million crime, there's money scattered all over the world. In fact, there's an investigation in Belgium. I mean, it's a very small amount of money. I think it's less than $1 million. We found money in Monaco. Interestingly, as you might expect, the Monegasque authorities are not very enthusiastic about investigating. We found money in France. The French authorities have investigated and confiscated. We found money in Spain. There's about $24 million of money frozen in Spain, and so the mission carries on. But this, you would spend your whole life if you had to work on the whole mission. I think Switzerland is what we're talking about today, and we should not let the money that continues to be stuck in Switzerland get returned to the perpetrators, because that would be a true travesty of justice.
Thank you. Professor, could I invite you to come in, please?
Yes, please, Chairman. Well, first of all, one has to say this, what we now call proportional method, has a legitimate area of application originally. And this, what it meant was, you know, sometimes when you are examining a laundering operation, you find money that is undoubtedly illegal, and then you stumble over money that where you cannot prove the illegality or where it is undoubtedly legal. And then the question is, of course, what you do if you have a pot with commingled assets, partly legal, partly illegal. And one way out was to say, well, imagine 30% is what people earned legitimately, 70% is what a drug dealer earned on the street. So you mix that in a pot, and then what happened was one said, okay, well, 70% are without question illegal, and as long as the person restricts himself to using the first 30%, he's not a launderer. He starts getting a launderer when he touches the definitely illegal part. And the alternative to that kind of approach was to say, oh, well, it's all a big mix, and up to the amount, up to 70%, it's illegal, and 30% is legal. This was the outset, at the outset, this proportionality method. But what I'm saying is it misses a very fundamental point, and that is this rule that is equally essential on surrogates, yeah, on substitution. So if you have 100% illegal at the beginning, and you use that, so the drug dealer buys a house, sells the house again, buys whatever the goods from it, all these substitutes stay fully illegal. And to be frank, in my piece that I wrote for the tribunals, which they didn't recognize at all, I said, well, the main problem is maybe not this proportionality method, it's actually that they did not apply the existing law. That the existing law is that surrogates remain, or substitutes remain, illegal. And then you don't, you never get to that point of actually reducing, continuously reducing at every stage of laundering the amount of illegal money. The difficulty was in this stage here, this court case here, they managed to play it in a way that over 4 stages of laundering at the end, there was nothing illegal left. And that is really the problem. I'm sorry that this may seem a bit complicated, but it's probably, one has to be really stubborn that everything that was illegal at the outset stays illegal, even if it's substituted by something, by other assets or other values. That is, for me, the most fundamental point. So I think maybe if we simply say on a worldwide basis, let's denounce the proportionality method, we are kind of not hitting the right point. What is more, the Supreme Tribunal in Switzerland didn't actually say anything about the method to be applied. They skirted the issues by saying Sir William has no standing, so we won't hear him. So there goes the issue. So if you ask me, they did not apply the method on surrogates or substitutes, which is fundamental. And what is more, they didn't do their job. I mean, that is what Bill is saying. They write in their case, in their documentation, we did not find any illegality here. That is the problem. An authority of a country that is a big financial center that is substandard. They did not do their job. That is my point.
Thank you. Konstantinos, did you want to come in with a question? I know the rapporteurs already addressed the experts, but if you have a further question.
I was, my question was regarding the measures which could be taken, and of course were already answered. But I thought, just a question remaining. What about pressing charges on individually? We have, in the common law at least, we have the system where you can file press charges individually. Private is called private criminal charges. In order to proceed with the to have international warrant arrest, and based on that, challenging or seeking either garnish order or Mariva ejection. I don't know, something which involved also criminal. My question is the criminal aspect of their actions. And finally, I want to confess that I admire your dedication on that issue. You are a brave man.
Well, thank you for that question. Just to put this in context, Vadim, my colleague here, has spent the last 15 years investigating this crime. And in that time, he's found the money going to, I believe, 24 different countries. And every time we find it going to a country, we file a criminal complaint with the law enforcement agencies of that country. And of those 24 countries, 16 countries have opened criminal investigations, including Switzerland, as we're discussing today. And there's just me, Vadim, and two others. And so we're relying on law and justice to do this, because for us to invest in a private prosecution in Switzerland, and by the way, we would be facing the same. Possibly, but I've tried actually universal jurisdiction, not on the basis of the money, but on the basis of torture and murder. And I actually, there's a famous law professor named David Crane, who he was one of the prosecutors at the International Criminal Court and on the tribunals of Sierra Leone, and he's retired now. But when he was in practice, he ran something called Impunity Watch and at Syracuse University. And he became interested in the Magnitsky case and in your particular suggestion. Well, I had the same suggestion that you've just made to me, which is, can we use universal jurisdiction to prosecute the people who killed Sergei Magnitsky and tortured him in a different country? And what we discovered is it's a beautiful concept that exists in a very sort of ephemeral theory. But when you actually put the rubber to the road, and what he did was he had all of his law school class each take a different country and put it into a report. And what they concluded was that there's basically, in theory, it sounds great. In practice, it wouldn't work anywhere for a lot of different reasons. Which is, by the way, why we decided to pursue this idea of the Magnitsky Act, because we said that international justice doesn't really exist. And if you can't get it by doing a prosecution, then at least countries can freeze assets and ban travel, which was the impetus for the whole Magnitsky justice campaign.
Thank you. Could I conclude by thanking both our experts for their contributions, which have been significant and important, and I'm sure will guide Ms Vasylenko as she comes to complete the work that she has undertaken on our behalf. So I will draw this session to an end, and we will stop the public hearing at this point. Thank you. Colleagues, The item on Pegasus will begin after the lunch and adjournment, but we will move on at this stage to item 10 on